Your name, sir?
Michael Horn.
All right, what are we doing?
Yeah, we're asking this matter be set for exam.
All discovery complete.
Yes, Your Honor.
People, other witnesses available the 25th?
This hearing starts off sounding procedural and calm, but underneath all the scheduling talk is a case that already feels loaded with tension. You've got prosecutors pushing forward on a serious shooting allegation, defense attorneys immediately preparing to challenge the strength of the evidence, and a judge trying to keep everything moving without getting pulled into speculation too early. And that's where things get interesting. Because in courtroom cases like this, the prosecution does not need dramatic evidence right away to create pressure. Sometimes all it takes is timing, association, and suspicion to justify keeping somebody locked under a massive bond while the case develops. But the defense is clearly signaling something important from the start. They believe this entire case is built more on assumptions than proof. Watch carefully as this hearing unfolds, because the arguments are not just about whether a shooting happened. The real battle is whether this defendant is actually connected to it in a meaningful legal way. Was he involved, or is law enforcement stacking circumstances together and hoping it looks convincing enough? And one thing viewers should pay attention to throughout this hearing is how often both sides rely on phrases like believed, understanding, and circumstantial. Those words matter. In criminal court, certainty and suspicion are two very different things. What would you need to hear before believing someone should be held on a $500,000 bond?
I'm sorry, Your Honor.
Would people have their witnesses available the 25th?
We'll try, Your Honor.
Preliminary examination in person, March 25th, 2025, 9 a.m. That's before Judge Moore.
May I address bond?
You may.
Yeah, this case was reissued after a dismissal. Do not see any objective reason why the bond should be so high, $500,000. Believe there's any witness or concrete evidence that my client fired any shots, or is there any witness or concrete evidence that my client was the driver of a car in which shots were fired from? Understand that we're going to have a preliminary examination in this matter, but from all the hours of body camera footage that I was able to review, witness statements, and I know cases can be made by circumstantial evidence, Your Honor, but I don't even see it circumstantially here. And when looking at my client's youthfulness, I don't think he's a flight risk. He has family in the courtroom, his grandfather, his girlfriend, his child. I think the court can look at a lot less restrictive means, house arrest, tether, to ensure the safety of the community and that he will not flee, Your Honor. But do not think that my client is a flight risk. And without concrete evidence that he fired shots at anybody or drove a car knowing that shots were going to be fired at anybody, I don't see how he's a danger to the public, Your Honor.
When you say it was dismissed, I mean, it's a reauthorization?
Yes, Your Honor.
That's correct, Your Honor. When it was up for exam initially, the officer in charge was out of town. So the case was dismissed at defense request and we did refile it.
Got it. Okay. Response to the
Your Honor, I do think the bond is appropriately set. We did put in our bond information form that this was a case involving shooting and the potential for shooting at a building. I do think that the facts in the case will be.
Now the prosecution begins laying out the emotional framework of the case, and you can already see the strategy forming. They are emphasizing retaliation, escalating violence, and the possibility that this was connected to another shooting involving the defendant's family. And legally, that matters because prosecutors know judges are not only thinking about guilt or innocence during bond discussions. They are thinking about danger, risk, and public safety. That is why the state keeps returning to the idea that this may have been revenge-driven violence. Even without presenting every detail yet, the prosecution wants the court to feel that releasing the defendant could create another dangerous situation before trial even begins. But the defense is also making a sharp counterargument here. They are basically saying, you are building a narrative first and looking for proof second. And honestly, this is where courtroom hearings become fascinating, because both sides are talking about the same facts, but framing them completely differently. One side sees a likely retaliation chain tied to a prior shooting. The other sees a young defendant being connected to a crime, mostly because his own family was victimized earlier that night. Those are radically different interpretations. And Judge Simpson is sitting right in the middle of it, trying to decide whether the circumstances alone justify keeping bond this high before the evidence is fully tested at preliminary examination.
Borne out, hopefully, the preliminary examination to give all of the factual basis for this case. This shooting on Andrea Street is believed to be in retaliation for a different shooting that was related to something else where this defendant was positively identified at that prior one on Knollwood. So we are asking that the court continue the bond and keep that earliest possible preliminary examination date of March 25th.
Yeah, may I respond? Right. So it seems to be that the people's theory is that because my client's mother's house was shot up, and he was present when it was shot up, he must be responsible for this other shooting, although no witnesses put him at the scene of that shooting, Your Honor. And I don't think that—
You're saying
at the second shooting. Yep. We will concede that there will be evidence that he was present at home when his mother's house was shot up. But that's it. There's no evidence that he left that location to go shoot up anybody else's house or drove anybody to go do that. And because of that, I don't think a $500,000 cash shooting bond is fair, Your Honor.
Anything else, Ms. Lundy?
No, Your Honor.
All right. Oh, okay. So the first shooting, when did that allegedly take place?
Approximately an hour to hour and a half earlier that night.
Oh, and we're not talking days.
It's very close in time, is my understanding, Your Honor.
Okay.
The car involved in the shooting was stopped. The second shooting.
Okay.
Was stopped that night by law enforcement. My client wasn't in the car.
He was not?
No, he was not.
Okay.
This right here is the moment the hearing suddenly becomes much more complicated for the defense. Up until now, the argument was heavily focused on the lack of direct evidence placing the defendant at the shooting itself. But then the prosecution introduces a major detail. The vehicle allegedly connected to the second shooting was registered to the defendant. And even though defense counsel immediately points out that the defendant was not actually inside the car when police stopped it, that ownership issue changes the temperature in the courtroom instantly. Because from a judge's perspective, this is no longer just random speculation floating around a retaliation theory. There is now at least one physical connection tying the defendant to the incident under investigation. And you can almost hear Judge Simpson mentally putting the timeline together in real time. The defendant's mother's house gets shot up. Roughly an hour later, another shooting allegedly happens. The vehicle involved is allegedly tied back to the defendant. That sequence alone is enough to raise serious concerns, even if it still falls short of proving guilt beyond a reasonable doubt. And this is why bond hearings can feel brutal for defendants. The court is not deciding whether the defendant committed the crime with certainty. The judge is deciding whether the surrounding circumstances create enough concern to justify detention while the case moves forward. Do you think vehicle ownership alone should carry this much weight in a hearing like this?
But it was, the car was registered to him, Your Honor. That is be a fact that we will be conceding at exam and trial.
Okay. So I'm not jumping to any. The car that was involved in the second shooting belonged to the defendant.
Yes, sir.
That approximately an hour before, correct me, but sometime just shortly before that, the defendant's mother's home was shot up.
Yes, sir.
Yes.
And Counsel, you said he was present at the home when his mother's house was shot.
He arrived after the house was shot up.
Got it.
He's on body camera, but he's not on body camera leaving in the car that is caught after the second shooting, the shooting we're here for. He's not in the car.
Okay. All right. I got you. I think. All right. Well, what I'm going to do at this time is I'm going to deny the request for the bond reduction. I'm going to leave bond set where it is. We're 10 days out or whatever it is from a preliminary examination. Let all those facts come out and then let Judge Moore make a decision as to proper release.
Yes, Your Honor.
Thank you.
Thank you.
Assistant Public Defender Asif Bashir here on behalf of Mr. Mark Capaldi. I have Mr. Capaldi was his custody status recently changed, I believe, 2 days ago, and I have not been able to be in contact with him. I have not.
Should I let you go on or should I read my note?
And just when the courtroom finishes dealing with a serious bond argument involving shootings and retaliation theories, the entire atmosphere shifts into something almost unbelievably awkward. This next segment feels less like a high-stakes criminal hearing and more like a judge slowly realizing a defendant may not actually show up to court at all. The defense attorney is already signaling communication problems, uncertainty about the client's status, and limited contact, which is never a great sign inside a courtroom. Then things somehow become even stranger. Conflicting stories start piling up almost immediately. Cars were allegedly stolen. Someone is allegedly jumping a vehicle. Community corrections is involved. Nobody seems entirely sure where the defendant actually is or how he plans to arrive. And Judge Simpson's reactions here are honestly what make this section memorable, because you can feel the patience wearing thinner line by line. Courtrooms run on credibility and accountability. Judges hear excuses constantly, so the moment stories start sounding inconsistent, skepticism rises fast. What starts as confusion slowly turns into courtroom comedy mixed with frustration. But underneath the humor is a real issue judges take seriously. If someone cannot reliably appear for a scheduled hearing, it directly impacts how the court views responsibility and compliance moving forward.
Thank you.
What do you want me to do? I mean, I'll let you talk.
Oh, sorry.
He said he's going to be late. He had to jump his vehicle. However, he does say unknown ETA.
Thank you, Your Honor.
Your Honor, the information I have is that I believe he told community corrections that both of his cars were stolen. Both?
Both of his cars?
Both.
When?
That's a great question, Your Honor. I don't know.
When did he tell community corrections?
I talked with Mr. Joshua Bennett today, and there were some questions about the tether zone and how big it was because the victim is the next door neighbor. I indicated that home confinement might have to work, and Mr. Joshua let me know he may not come today. He claims both of his cars were stolen, and community corrections told him to talk to his attorney. So I'm going to ask.
I'm just trying to figure out. But he's jumping his vehicle.
Right.
So does he have 3 cars?
That's a really good question.
I don't know.
But I know where he's not, which is here. So I'm asking for a warrant.
What? He borrowed a car with a dead battery. Oh, that's all he could get?
Your Honor,
What would you like me to do, Mr. Chair? Since we have conflicting messages.
I will, in light of the, Mr. Capaldi has, contacted the court ahead of time. I would request that we pass this matter and address it, and I can try to look for him.
Are we really just postponing the inevitable?
Alternatively, I would request an adjournment in this matter.
Yeah, thanks. Nice try.
Judge Simpson's nice try response lands like a hammer because by this point, the court clearly feels it has heard enough explanations for one morning. And honestly, this exchange perfectly captures the balancing act judges deal with every single day. On one hand, courts do try to allow flexibility when legitimate emergencies happen. Cars break down, transportation issues happen, life happens. But on the other hand, judges also see endless delay tactics, vague excuses, and last-minute stories from defendants who simply do not prioritize appearing in court. That is why credibility becomes everything. Once a judge starts doubting the reliability of the explanation, every additional excuse sounds worse instead of better. And notice how Judge Simpson immediately references prior weeks. That is important because courts absolutely remember patterns. A single late appearance may not be catastrophic, but repeated scheduling problems create frustration quickly. Then the hearing drifts into almost sitcom-level absurdity when the court starts trying to figure out how someone allegedly had stolen cars but is also jumping a vehicle to get there. The logic just is not landing cleanly. Yet despite all the sarcasm and visible irritation, the judge still gives the defendant one more opportunity by passing the matter temporarily instead of immediately escalating consequences. That shows restraint, even while making it crystal clear the court is not buying the story very easily.
You know what? We did this last week with you, didn't we? And the week before. Something with your client.
I will note that.
No, let's see if he has a car.
Okay.
So I'll pass it.
Thank you, Your Honor.
I can't wait. Do you think? No.
Assistant Public Defender Asif Bashir on behalf of Mark Capaldi, who is here.
State your name.
Mark Capaldi.
This is a miracle. So let me
More than a year.
So, all right, he's here. I had faith in you. I don't know what all these other people.
I had none. I was losing. I lost all faith.
Well, no, you contacted the court. You told us you'd be running late. You're trying to get a job for you. You got here. That's important.
Hey, just came to see you.
It's great to see me. All right. Thank you, sir. All right. Did an adjournment of this?
For putting my file to the side and
Pardon?
thank you for waiting for me to put the file to the side.
Not a problem. You think that young lady next to you, she's that got me to do that. So 4 weeks, you think, for the information?
Yes, yeah, thank you, Your Honor. 4-week adjournment requested.
Probable cause conference, April 10th, 2025, 9 a.m. Bond will continue.
Thank you, Your
Thank you, sir.
All right, thank you. I don't know. Ashley? All right. I'm now going back and stand in recess, I think. All right, court's in recess.
This hearing ended with two completely different courtroom energies colliding into one unforgettable session. In the first half, Judge Simpson dealt with a genuinely serious bond dispute involving allegations of retaliatory violence, disputed evidence, and a defendant facing an enormous $500,000 bond. The defense fought aggressively to frame the case as circumstantial and unsupported by concrete proof, while prosecutors argued the timeline, vehicle connection, and retaliation theory justified keeping Bond exactly where it was. Ultimately, Judge Simpson sided with caution and denied the bond reduction, choosing to leave the existing bond in place until the preliminary examination could reveal more facts. That decision tells you the judge believed there was enough concern surrounding the circumstances to avoid lowering restrictions this early in the case. Then the courtroom shifted into total chaos with the Capaldi hearing, where confusion about stolen cars, dead batteries, and uncertain arrival times created one of the more unintentionally entertaining exchanges of the session. Judge Simpson's sarcasm and frustration made it obvious the court was testing the credibility of every explanation being offered, but in the end, the defendant did finally appear, avoiding what could have become a much worse outcome. What makes hearings like this fascinating is that they show both sides of courtroom reality. Sometimes it is deadly serious legal analysis about violence and public safety. Other times it is human unpredictability colliding headfirst with courtroom procedure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.